But anyhow, this bill would allow the DOA to extend the consistency for up to 2 years, that deadline, for communities that had a grant. That's intended to try to get people to complete it, not just cut them off. It avoids potential litigation. That's the first thing, extending the consistency requirement for those that got grants. It does not extend the consistency requirement for communities that just didn't plan. In other words, there were some communities that just aren't going to do it, they don't get any extension. Also, there were some communities that got grants, Clark County, Washburn County, real early in the game, 7, 8, 10 years ago, and then didn't adopt the plans. They wouldn't get an extension because they didn't go ahead and complete it. So that's a limited extension for those people that have gotten grants and haven't completed. The next big issue, it would provide a definition of consistency, which is intended to give some limits to courts, so that when they ask, is it consistent or not consistent? And the term consistent is defined with consistent with the goals, objectives of the plan. So in effect, it's to give some limits to courts just saying, well, I wouldn't have found it consistent. In effect, the court is to judge it based on your plan. And in your plan, each of those elements identifies goals and objectives, and that's what you can point to then is the action and zoning or subdivision or official map consistent with your goals and objectives. It gives some limits, and that's good. The next thing the bill did, it said specifically that adoption of a plan, a comprehensive plan, by an ordinance is not a regulation. Some of the anti-planning people have run around the state saying because a plan is adopted by ordinance, and that was intended so that the elected bodies adopted as opposed to the planning commissions who were appointed, had to be adopted by ordinance, and they were saying, well, it's a regulation. You don't regulate issues by the plan. You regulate by zoning, subdivision, official map, which have to be consistent with your plan. But if you don't have a zoning, don't have a subdivision ordinance, or don't have an official map, you can't say no based on your plan. It's not the plan that's the regulation, it's the zoning, subdivision, official map. And this specifically says that. And the last issue that relates not to urban towns, how many of you in this room have village powers? I think most of you have village powers. The original planning bill said that towns had to have village powers to adopt a comprehensive plan. We've had some towns who went through the planning process where the groups that were against planning came to an annual or special town meeting and took away village powers with the idea of stopping planning. The bill says now that the town board can adopt the plan, doesn't have to have village powers. But for response to this, you're going to have some people say, well, this then means that the board can adopt zoning? No, it does not mean that at all. In fact, zoning can only be adopted with village powers, can only be adopted with a vote of the electors. So it does not give any greater authority to zone. But where it is important, and we have 700 plus towns that are under county zoning, not all of which have village powers. Under county zoning, a town board can veto a zone change. All of you that are under county zoning can veto it. And the question that came about as a legal issue is, can a town board veto a zone change, going from agriculture to residential, or agriculture to commercial, or whatever change was, if they don't have a plan to be consistent with? This will allow towns without village powers to in effect have a plan and to fully exercise that veto. It'll take away one potential challenge that might arise. Fairly limited situation, but it actually protects those towns. So that bill was agreed upon by the League, the Alliance, the counties, and 1,000 Friends, the realtors and builders. It was put together over a period of actually 18 months until we got the final version out, but it is agreed upon. I'm sure that the governor is going to sign that. Senate Bill 601. Any questions on that?
Yes, sir. Number 2 there,